Okay, so let's start with the big one. So when a founder passes away suddenly, especially without clear estate structures, so what happens to the business?
I guess if you talk about that kind of situation, you really have to demarcate when you talk about the founder's departure, in what capacity he's actually departing the company, and then you determine what's the impact, right? Because when you commonly talk about a founder leaving, you just think of one individual leaving the company, and then when you apply the terminology of founder, you think the impact is going to be very big, but you don't really know how to demarcate the impact. Because when you have a founder situation, founder doesn't connect a legal definition. It just means the person who started the company. But how his departure will impact the company depends on his role within the company. Not exhaustive, but several roles one may have. For example, the typical one is shareholder. So if he's a founder, likely will hold quite a significant proportion of the shares. So if he leaves as a shareholder, then what happens to his shares? That's one question. Often he will also hold a position on the board, right? So directorship. So if he leaves or upon his demise, for example, what happens at the board level? That's another question. But the common misconception is, for example, if he's also a CEO or COO because he's the founder, then that also connotes a different kind of relationship, which is perhaps an employment relationship. And so if he leaves at the employment level, then that's another different kind of impact for the company as well. So depending on which capacity you are talking about, the kind of open inverted commas succession planning that you have to consider will be different. Shares, for example, no-brainer lah. You have to have a will and you make clear instructions as to who gets your shares. But that's just the front end, because the back end, if your company's constitution or existing shareholders agreement contradict that, then you get into problems. At the board level, another set of questions as well. But again, depending which capacity you're talking about.
I see. So let's say if we use a Tipsy Collective's case, right? The team reportedly fast-tracked a handover plan that just before Derek's passing in, right? So in your experience, how common is that in succession planning or contingency plans only come into effect when a crisis is already unfolding?
I guess the question is not so much whether it's common or uncommon, because by the very description of what you have said, a contingency plan can only come into effect at the precipice of a crisis. So that's the starting position. The question, I feel, how business owners or founders prepared to invest not just money. I always say as investment as of that intellectual capital to figure out all possible scenarios where the company may be at risk and to plan for those scenarios. So is it very common for companies or founders to not have this kind of plans in mind? Actually, in my experience, very, very, very common. And don't even talk about planning for contingencies or planning for exigencies. You talk about basic things like shareholders agreement. Some companies don't even bother to draft that, especially the family kind of family-run businesses, for example. Not just family-run businesses, in my experience, some very, very big, larger corporations also don't even bother to have a shareholders agreement. And so, again, it boils down to that. I wouldn't say unwillingness, but the inability to look ahead, to invest ahead of time their intellectual capital to try to preempt problems. And so when the problem surfaces, not that it becomes unsolvable, but it becomes more difficult to solve. And when a lawyer tells you it's more difficult to solve, typically it means more expensive to solve as well.
I see.